If we can have counsel for the first case, please show your cameras, and everyone else, if you can go ahead and mute your video, that would be appreciated.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Welcome to the remote version of the United States Court of Appeals for the Fourth Circuit. We have three cases on for hearing this morning. The first is 23-6914, United States versus Boyd. Ms. Tarleton, whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court. Jackie Tarleton for Robert Boyd. The district court returned Mr. Boyd to prison based on the government's allegation that he possessed adult pornography, and as a result of that possession, that he would have serious difficulty refraining from child molestation if allowed to remain in the community. It did so against the clear weight of the evidence. First, the government failed to prove by a preponderance of the evidence that Mr. Boyd knowingly possessed the images. He quickly initiated contact with his probation officer, treatment provider, and lawyer as soon as his computer was remotely accessed. That remote access of his computer was supported by a forensic examination, and he passed a polygraph about it. Mr. Boyd immediately consented to search of his computer and the SD card. Officer Ellis found nothing suspicious on his computer, but nonetheless sent it off for forensic examination, which again confirmed that that computer did not access these images. The forensic examination offered no evidence that Mr. Boyd was aware of, accessed, or viewed the pornographic images. It found no unauthorized material on the laptop and conducted no analysis of any other device beyond her belief to determine whether those devices could have even accepted an SD card, let alone that they accepted this one or viewed these images. There was no forensic testimony in this case, which is remarkable. Usually in pornography cases, we expect the government—
But there was testimony from appellant, and the district court found that appellant had repeatedly perjured himself and, not to mention, minimized his conduct. And doesn't that credibility determination by the district court, and we owe it strong deference?
That's fine, Your Honor, and Mr. Boyd has acknowledged his difficulty with telling the truth in the past. However, there is still a burden of proof on the government in this revocation proceeding. And so, in my view, the government has to put on evidence to get beyond a preponderance, that it's more likely than not that Mr. Boyd knew these images were in his possession, and that as a result of knowingly possessing those images, that he was then sexually dangerous. And I don't believe the government's met that burden here, even if the district court was entitled to disbelieve Mr. Boyd himself. The government didn't put on anything separate and apart from Mr. Boyd's testimony that would establish that he had viewed these images. And in
Ms.
other
Tarleton,
cases— yes.
sorry to interrupt you, but maybe not any direct evidence, but in addition to the credibility issue, wasn't there evidence that the images in this case came from the same website or origin that the earlier images that he had been found with and either prosecuted with or had his revocation, had his release revoked? So we've got that evidence. And the very nature of the SD card would suggest, I mean, there's no question he had in possession the SD card. He didn't say otherwise. So how would those images have gotten on that card, but for the fact that he owned it and put them on there?
Two responses, Your Honor. First, with respect to the nature of the images, yes, they were from the same website as previous images that Mr. Boyd had been convicted of viewing. However, the government put on no evidence that this was a particularly rare website, and this is a common target for folks who have this issue. So that age range is not unusual in these cases. What's more, even
the age range is not unusual, but the particular website and the actual name of the website being the same one that he had been found with having images from a decade earlier, that seems much more than a coincidence.
It was the same, but Your Honor, there was no evidence put on about how rare these images are in these kinds of cases. And even if the court believed that Mr. Boyd knowingly possessed them, I still believe the government never proved by a preponderance that he ever accessed or viewed them. And that I think is really significant in this case.
And I know you had another part two answer to Chief Judge Diaz's question, and I interrupted, so go ahead and continue.
I did. And with respect to the SD card, he acknowledged that he possessed the SD card. It was a little odd that it got sent off and the images came back on a different SD card. But even assuming that it's the same that was seized from him, he was living in a housing complex that had a lot of supervisees. And so he said that he borrowed the SD card from someone else. And so it's possible that those images had already been loaded by someone else and that he was unaware of them.
From a neighbor that he didn't know and couldn't identify what apartment they were in. That was his testimony?
That's true. But I still think there is a burden on the government by a preponderance to show that he ever accessed or viewed these. And it's not hard.
And that neighbor, again, sorry about this. It's just the nature of the beast. That a neighbor who apparently himself was a sex offender. Do I have that right?
We don't know. We don't know.
Well, you said that didn't you just say that the apartment housed a number of people on that were on supervised release or might be sex offenders?
Yes. And we don't know who the images came from or who the SD card came from. But my point is that I would have expected the government to present forensic analysis to say, this is when the images were loaded on the SD card. This is when they were accessed. This is when they were viewed, and possibly by what device. There was a suggestion that Mr. Boyd viewed these images on something other than his laptop, but the government never sought to examine any other devices, never established that any of those other devices even could receive an SD card, let alone that it had used this SD card.
And were those other devices, was he allowed to have those other devices?
So there were a few that were discussed in the testimony. The computer was the laptop that Mr. Boyd was permitted to have. It had remote comm software that never alerted to any inappropriate conduct. And the forensic examination of that computer showed no unauthorized images were present. The Gab phone had no internet access. There was no testimony or evidence that it could accept an SD card or that it had accepted this SD card. He had a tablet with no internet access that he was permitted to have. There was no testimony about that being able to receive an SD card or receiving this SD card.
Was there evidence that he claimed that he used the SD card for gaming? Do I have that right?
Yes, to store a game.
Okay, but in order to store that game, he would have had to have loaded the game onto the SD card, right?
Yes, and he admitted that he loaded the game on the SD card. But we don't have any testimony or forensic evidence about him accessing these other images. And we don't know if they were in allocated or unallocated space. We don't know if they had ever been opened. We just don't know anything about them. Yes, Judge Berger.
Ms. Tarleton, as I understand it, the condition of relief says possession. It doesn't say viewed or accessed. So how is it then that the government has to prove that he accessed them as opposed to simple possession, which is the condition of the release?
I think it's relevant in two ways, Judge Berner. First, I do believe that knowing possession is inherently required in order to revoke someone's conditional release under Condition 37, which he was alleged to have violated in this case. But also, Perkins and McNair established that there's a second finding that must be made, which is that as a result of this violation, that he is then sexually dangerous. And sexually dangerous in this context means that he will have serious difficulty refraining from sexually violent conduct or child molestation. I think it's already a leap to say that possession, even knowing possession of legal pornography, makes someone have serious difficulty refraining from child molestation. But even assuming that's true, I think it at least requires that the person was viewing that material or knew it was there or accessing it in some way. Otherwise, it might even be evidence of volitional control to know those images were there and choose not to view them.
Was the expert who made the assessment that he was sexually or could be sexually dangerous, did he rely on the notion that your client would have had to have viewed the images?
I think he assumed, as the district court did and as the forensic examiner did, that Mr.
The
Boyd
reason I
did
asked
view the
that, and I'm
images.
sorry to interrupt you again, but is because it wasn't just that, although obviously that was critically important, but there was other indicia that he was having trouble complying with his conditions of release, including engaging in conversations with a pubescent or a teenager, I guess, at a Burger King, and viewing maybe not explicit pornography, but sexually suggestive videos on TV and other outlets. So admittedly, that the evidence of the SD card and the pornography therein was critically important, but it wasn't the only evidence, right?
That's true, but I think there are flaws in that other evidence. First, with regard to the TV that he was watching, he did purchase a smart TV, and the testimony was that he was viewing art, albeit some of those art images had nude bodies in them. But
did the probation officer permit him to have the smart TV?
No, but he was not expressly prohibited from it. Once he bought it, the probation officer saw it, told him to return it, and he immediately did.
What about, did he have 2 smartphones?
He had a Gab phone, which he was permitted to have. He had a tablet with no internet access, which he was permitted to have. And he purchased, without authorization, a tablet with internet access, but that was still in the box unopened when Officer Ellis came to his home. With regard to the smart TV, I do think it's important to recognize this is someone who's institutionalized, has been in prison for decades. And frankly, I don't fully understand how smart TVs work. And so the fact that he purchased it, but immediately upon being told it was not appropriate for him, returned it, and there was no further question, no revocation motion followed from that incident, is important to recognize. With respect to the Burger King, first of all, I want to say that it's important, this court recognized in Antone that these folks participate honestly and forthrightly in treatment. Mr. Boyd did that in this case. Absent his own contacting of his probation officer, no one would have known about this SD card. No one would have known about this contact at Burger King. The contact at Burger King.
Wait, was he the first one to bring up the contact at Burger King?
He was. Officer Ellis asked anything you want to talk about. It was a very generic question.
And I guess no one would have known about the multiple contacts at Burger King or the SD card at the time they found out about it because he contacted them, but eventually that would have come to light.
Perhaps. I mean, I think the Burger King, first of all, the multiple instances I don't think is supported by the record. The only person who was present was Mr. Boyd, and he said that the incident happened once and that there were multiple discussions with Officer Ellis about that one incident. There's no indication whether this young man was underage or not. And honestly, he did exactly what we hope he would do during an incidental contact out in the community. He saw someone.
Can you explain and I do recognize that he did call his probation officer about this SD card, but as I've read everything, it seemed like his story about the SD card evolved from when he first called the probation officer and what he told him then to what he told the probation officer when he showed up at the house.
Respectfully, Your Honor, I would disagree. I think he did acknowledge that his computer was hacked. That was confirmed by the forensic examination, that this ultra viewer remotely accessed his computer. There was some confusion about whether bank information was requested, but Officer Ellis was very equivocal on that testimony. He said he didn't really remember, he wasn't computer savvy. So I don't think that Mr. Boyd's story changed in any material respect, and I do think it was confirmed by the forensic examination that was ultimately conducted by Ms. Thiemann, that his computer was remotely accessed. With regard to I just want to go back to the Burger King for a moment, if I might. I don't think it's supported that there were multiple instances. I think Mr. Boyd was doing a lot right. Antone recognized that these pedophilic and hebephilic conditions are lifelong. These are something that these folks will struggle with forever. even once they're released into the community. And so what we are asking for them once they are released is that they can encounter these situations in the community and that they deal with them with their treatment provider, with their probation officer, with their lawyer, as Mr. Boyd did in this case. He immediately called his probation officer, his treatment provider, and his lawyer when his computer was remotely accessed. He discussed the incident in the Burger King, and it didn't escalate in any way. He talked about some thoughts that he had, but he didn't approach the young man. He didn't pursue it any further, and that's what we want to happen. Antone gave the example of alcoholism. If someone who suffers from alcoholism passes wine in the grocery store, one might expect them to have thoughts about it and to talk with their resources about those thoughts. But if they don't buy the wine and they don't take it further, that's a success. And that's what we want to happen, and that's what happened in this case. Mr. Boyd also talked about other times when he successfully dealt with situations in the community. There were 2 instances where young men boarded buses, public transportation that he was on, and he got off the bus. He was participating with his sex offender treatment. He was participating with medical and mental health treatment from the VA. He was registering as a sex offender as he was required. A lot of the testimony from Officer Ellis about why did he have this, why did he have that, those things had not been expressly prohibited before. So I think when Mr. Boyd was made aware of a violation or a problem in his time in the community, he responded appropriately. He returned the smart TV. He cooperated with Officer Ellis and initiated that contact with respect to this computer and SD card. So I think Mr. Boyd was not without his missteps, to be sure, but overall he was doing well. I mean, even after this computer incident, he spent 5 months in the community continuing to participate as we would hope.
Ms. Tarleton, can I ask you about the polygraph? And I'll begin by saying that I agree with you that it seems odd that someone would voluntarily turn over evidence that he might well know would lead to his revocation, but that wouldn't be the first time, I suppose, but it does strike me as suggesting anyway that he may not have known what was on that card. But what are we supposed to do with the polygraph evidence? You mentioned it, but it's not admissible evidence. It comes up in the papers, but do we consider it at all? And if so, in the face of cases that suggest otherwise. So what's your thought about that?
I don't think it's necessary to this court's decision. I think in light of Mr. Boyd's struggles with honesty in the past, it's helpful to support his statements and his credibility on these specific issues. But I don't think it's necessary. I think what's important here to remember is that the government had the burden by a preponderance. Perkins and McNair established that that is true. They failed, in my view, completely to put on the appropriate record to support either that he knowingly possessed this material or that as a result of possessing legal adult pornography, he would have serious difficulty refraining from child molestation. And where we're doing this complex analysis about previewing future behavior and incarcerating someone in a federal prison because of what we suspect they might do. I see my time is up. May I briefly conclude?
Please.
I think it's very important for this court to hold the government to its proof on the underlying facts, which I don't think they established here. So we would ask the court to reverse.
All right, thank you very much. Ms. Petre?
Morning. Jenna Petrie for the United States of America, and may it please the court. Good morning, your honors. This court is asked this morning to address whether the district court properly revoked Mr. Boyd's conditional release under the Adam Walsh Child Protection and Safety Act of 2006. This court should affirm the decision of the district court finding that the 47 pages of oral findings entered into by the district court in this case amply support a finding by the preponderance of the evidence that Mr. Boyd both violated the conditions of his release and that as a result of those violations, he would have serious difficulty refraining from child molestation or sexually violent conduct.
What supports the finding? What evidence was there that he knowingly possessed the images that were on the SD card? He certainly knowingly possessed the SD card, but what's the evidence that he knew those images were there?
I think your honors have pointed to a number of issues already as it relates to the SD card, that Mr. Boyd didn't know where it was from, couldn't tell us who provided it to him, which all begins kind of to be very suspect. But then during the forensic analysis of that card, what we see is that it was used both for SimCity and to have these 91 images of child pornography. And there were multiple files of SimCity on this SD card that were revealed during the forensic analysis. When Mr. Boyd was questioned about the use of the SD card, he specifically noted it was used for gaming and admitted that he had put SimCity on the card. Now, in order for him to use that gaming system, he would have had to access the card, access the files on the card, and then click on them in order to play those
But I
games.
think Ms. Tarleton said there wasn't any forensic evidence as to where the images were, if they were in unused space or like if he would have actually seen those even when he used the SimCity gaming on that card.
That's correct, Your Honor. There's no specific evidence as to where those were contained. However, they were all on the same card. There's no indication that there were any file folders on the card, as the forensic analysis would have noted that. So to then posit that there were these separate secret places on the card, on the SD card, that could have been accessed, seems to make little sense in this situation. And so based on that,
Ms.
the court
Petrie?
made, my apologies.
I just want to go back to something you said because I want to clarify. You said that on the card were found images that were child pornography. My understanding is that there was no such finding, that in fact, what Judge Dever found was that there were images from a website that had included men that were of the age of majority. Is that right?
Yes, Your Honor, my apologies. I did misspeak. I believe what the court specifically found were that the images were child pornography. The evidence presented by the government was that all of the images, the 91 images, contained nude individuals that may have either been under the age of 18 and thus children, or were individuals who were purposely appearing to be childlike in nature.
Well, the website itself said Teen Studio, correct?
That's correct. It was gayteenstudios.com.
So anyone getting that website would have assumed it would have been teens.
I
Or
believe
at
that's
least-
correct, Your Honor. And the United States probation officer from the Northern District of Ohio, who viewed all of these images as part of his investigation, did indicate that while he could not be sure that they were teenagers, he felt that they were meant to look like teenagers, meaning that they didn't have a lot of musculature, they didn't have any facial hair, they had minimal pubic hair.
Well, the name of the website itself indicates that they're meant to look like teenagers, right?
I agree, Your Honor, yes.
But I do have another question about the forensic examination. Opposing counsel said the forensic examination actually showed that the computer was hacked, which would have corroborated appellant's story. What's your response to that?
I don't think the word hacked is perhaps the right word here, because I think it implies some kind of nefariousness that we don't have information related to. There was some kind of access to the computer by a third party, and that evidence was confirmed. However, it couldn't be sure whether or not Mr. Boyd had accessed it from his own phone or from his tablet in order to create this appearance that something had gone wrong. And perhaps the mere fact that he had plugged in the SD card to his computer, knowing that there was child pornography, is what precipitated this whole event. We can't be sure because, as the court noted in this case, Mr. Boyd was historically deceptive and manipulative of the evidence. He often downplayed or minimized his own behaviors. And in fact, in this court case, the district court determined that he was not credible and inferred the opposite of his testimony.
What about the fact that, I'm sorry to interrupt, that he was the one who brought all of this to the attention of the probation officer? The government would not have otherwise known about this, but for the fact that he came forward and said, look, a computer has been hacked. You say maybe it wasn't, maybe there was something nefarious about that, but all that, what troubles me is that he came forward and laid this all out for the government.
I certainly understand the court's concern about that issue. Unfortunately, I can't deem to imagine what Mr. Boyd was thinking in those moments and why he might have called his probation officer. As I mentioned, for all we know, it could be because he accidentally plugged the SD card into his computer and became afraid that the remote access and all of that, the files by the probation office would sense those images on the SD card. I can't begin to guess why Mr. Boyd called, but I think what's relevant is what Judge Thacker noted earlier, that Mr. Boyd's story changed over the course of the events, and it even changed when he was at the hearing. Initially, when he called Officer Parrish Ellis, who was the probation officer in this case, he indicated that he believed that his computer was locked because someone in the apartment complex had accessed child pornography. Then upon Officer Ellis's arrival at the home, it was, oh, there might be child pornography on my computer. And never did he indicate that there was anything with his banking information. He didn't indicate that he had to call anyone. But then when we get to the hearing, all of a sudden he had to call 2 different people. He had to provide banking information. And so the story seemed to develop in somewhat of a strange way. And I think what it all boils down to is the fact that this can't just be a coincidence. In 2010, Mr. Boyd was caught with multiple images from the same exact website, gayteenstudios.com. He has a copious history of possessing either pornography or child pornography. He was kind of noted in the original commitment hearing to be somewhat of a collector of child pornography, someone with both hands-on cases against children and a collector of child pornography. And so then when we see it here, these 91 images squarely within the type of individuals that Mr. Boyd has predated on historically, the type of individuals he's always been interested in, these teenage boys or these appearing to look like teenage boys. This can't be purely coincidence. There was not a single female in any of the images, not a single child or person appearing of pubescent or younger age. So all of this evidence really added up for the district court to help that finding by a preponderance of the evidence as required by this court in United States versus Perkins to make that first finding of our analysis that he did in fact violate the conditions of his release.
So, and let me make sure I understand your answer to my very first question about the evidence that he knowingly possessed the images, not just that he knowingly possessed the SD card. It's that the SimCity game was on there and had been accessed on the SD card. It's that the Gay Teen Studio website is the same one that he had accessed a decade earlier, and also that the images were the type of individuals he's consistently been interested in since the time he was in his early 20s.
Yes, Your Honor.
Anything else?
I believe the additional piece that the district court did consider in this case is that Mr. Boyd specifically denied knowledge of the child pornography and denied possessing the child pornography. And as I noted earlier, the court did find that because he had perjured himself and because he had previously minimized his conduct, that it could infer the opposite of that testimony. So I do believe that that's an additional piece that the district court considered in making its finding, and it noted that in its oral pronouncement of the opinion. Now,
Yes, there was Ms. Tarleton mentioned that the SD card, there was no evidence, the government presented no evidence showing that the card itself had been accessed or files within the card had been accessed. And maybe this isn't in the record, and if it isn't, you may not be able to answer, but is there a way to do that, to show whether or not a particular file on an SD card has been accessed?
I don't believe so, Your Honor, and I certainly don't believe that there's a way to show that a specific device has accessed anything off of a card. Because the card is the storage device, and so all of that would be stored on there. There's no storage on the actual device system. And so I don't believe that that would be the case. And moreover, Your Honor, I would know.
But if he had, if he had accessed the card after inserting it in the computer, the software designed to detect that would have shown that, right?
Quite frankly, Your Honor, I'm not sure that it would have detected it unless that particular image was opened on the computer. I'm not sure whether or not the security on that was placed on those devices by United States probation has the ability to detect the SD card and items contained on a separate storage device, and there was no information in the forensic report related to that.
Oh, okay, because I thought, going to the forensic report, I thought the question was about the forensic exam, not whether what the probation put on it could tell, but whether the forensic exam could tell whether the images had been accessed or not, because I thought the forensic exam said that SimCity had been accessed. You could tell that SimCity had been played on there, so why couldn't the forensic exam also tell whether or not the images had been accessed?
Your Honor, I'm unsure that that's precisely what the forensic exam said. I believe what the forensic exam noted was that SimCity had been placed on the card multiple times and that there were numerous files. I don't believe that the forensic examination was able to indicate specifically the number of times that they had been accessed.
Okay.
Ms. Mitri, I do find it disturbing that the forensic report itself was never put into evidence, that Officer Ellis was permitted to testify about what the report said, but the report itself was not put into evidence. Is that right?
No, Your Honor. So the United States did submit that report into evidence, and it was accepted, excuse me, it was not accepted by the court, but it was considered by the court in that the court allowed each of the experts to use the information gleaned from that report. The court declined to enter it into evidence and did not submit it for the truth of the matter, but did allow both the probation officer and both of the experts to testify related to it.
So we have no way on appellate review to know what actually was in the report, apart from what the experts said was in it.
Well, it has been submitted as part of the joint appendix in this case, and so it is included for this court's consideration. And I'm happy to provide a JA site if that would be helpful to the court.
That would be helpful. Thank you.
Absolutely, Your Honor. The forensic report is located at JA 454. And one of the significant things I think we've heard Mr. Boyd argue numerous times throughout today and in his brief, that the government was required to have certain testimony or certain specific evidence in this case. And that's actually not true. So this court in United States versus Mason noted that the government's not required to use any specific investigative techniques, nor is it required to present any specific evidence of that kind to the finder of fact.
I think what the point opposing counsel was making is that the government does have the burden of proof and needs to present evidence sufficient to meet that preponderance of the evidence burden. That's the way I took what opposing counsel was saying.
Yes, Your Honor, and I believe that the United States did meet that burden of preponderance of the evidence here, and I think the court.
And what's our standard of review now on appeal?
It's clear error, Your Honor, and so this court might hear all of the evidence and determine perhaps that it would have decided the case differently had it been the finder of fact, but that's not the standard under clear error. Rather, this court has to be left with a definite and firm conviction that a mistake was made based on the totality of the evidence. And I think that piece is really important here, because what I think Mr. Boyd is asking this court to do is to view this violation somewhat in a vacuum, right? To consider nothing else except for the fact that he had pornography in his possession. And that's not supported by this court's decision in United States versus Perkins or United States versus McNair, nor does it really make sense when we consider the violation of someone being in the community. Rather, I think it's really important here that we look at every little thing that Mr. Boyd was doing in the community. And that's exactly what the district court did in making and rendering its decision, especially as it relates to the second prong of the analysis, which is whether in light of the violation conduct, Mr. Boyd would be sexually dangerous to others if he continued on conditional release. And for the court, what it really felt was that Mr. Boyd was building and escalating his conduct over the course of time. And while Ms. Tarleton noted earlier that Mr. Boyd was in the community for 5 months after being caught with the pornography while they underdid an analysis and he was fine and great, that's actually not what the record says. What the record tells us is that while we were waiting for the forensic analysis to come back, this is when Mr. Boyd was going to Burger King time and time again, every time he had a meeting with his provider in the community, and that on at least 3 occasions he reported being waited on by a teenage boy and having some kind of feelings or expectations that this child was flirting with him or interested in him in some way.
And didn't either his counselor or the probation officer or both tell him then stop going to that Burger King, but he still kept going back to it?
That's exactly right, Your Honor. And Mr. Boyd, from years of being in treatment, from being in the community where he alleged that he was getting so much more out of treatment than he ever got while he was in the commitment and treatment program at Butner, he should have known that he was putting himself in a situation where he was tempting himself to offend, right? We heard him testify somewhat self-servingly that he got off the bus because a kid sat next to him, or he had removed himself from these other bad situations. But now, all of a sudden, we see him putting himself in the same bad situation time and time again. And even during his testimony during trial, when questioned about whether or not he was attracted to boys in this age range or whether he was attracted to the boys at Burger King, he initially denied that and said no. And then when pushed further, he admitted, well, maybe for a second I thought about it. Maybe for a second I thought about calling or asking for their phone number. Like maybe for a second I thought that they were flirting with me.
Well, but Ms. Tarleton says that's the whole reason why he is where he is. He's got this lifelong disease that he has to deal with, condition, and related to the Burger King incident. Once again, this was the Mr. Boyd coming forward to his probation officer saying, "Look, here's what happened. Here's what I'm doing." So, you know, again, the probation officer would not have had any reason to know about that for the fact that Mr. Boyd came forward and admitted that he had these feelings again.
I don't disagree with the court on that point, but I apologize, Judge Berner.
Thank you. I know this is difficult. It's hard to navigate court on Zoom. I just wanted to follow on Chief Judge Diaz's comment because I'm looking at the revocation statute, and the language of the statute says that the court shall remand to a suitable facility in light of an individual's, and this is the language, failure to comply with the prescribed treatment of medical, psychiatric, or psychological care or treatment. And I don't see any evidence that Mr. Boyd actually failed to comply with the prescribed regimen of medical, psychiatric, or psychological care or treatment. In fact, what strikes me is that there was compliance of all of the requirements of care or treatment. I hear you speak about perhaps indications of potentially going down a path towards sexually dangerous behavior, but that doesn't seem to be treatment related. In fact, he was complying with his treatment related conditions, was he not?
It does appear that he was complying at least superficially, though I think there's evidence in the record that even his the social worker who was working with him in the community had concerns about him, especially related to the Burger King incidents, Your Honor.
Well, but what the statute says is the remand is if the individual is found to be sexually dangerous to others in light of a failure to comply with the prescribed regimen of medical, psychiatric, or psychological care or treatment. And again, I don't see or hear you speaking of any evidence that there was a failure to comply with the prescribed regimen of treatment.
Your Honor, I see that my time has just expired. I would like
Please
the
answer.
opportunity to address both yours and Judge Diaz's questions, if I may.
Go ahead.
So beginning with as it relates to the prescribed regimen of medical, psychiatric, or psychological care that's prescribed by 18 U.S.C. 4248, I believe that this court is actually hearing another very similar case on this idea of ancillary conditions. And so what has been argued, I believe in that case, and I think, if I'm correct, that it's United States v. Roney. There's also United States versus Williams, which is pending the final decision of United States versus Roney on the same issue. But what the issue is in that specific case, and what the issue is here, is whether or not the district court in placing conditions on a person can include what some other courts have called quote unquote ancillary conditions. So these are conditions that are related to the prescribed regimen of medical, psychiatric, or psychological care, but not necessarily specific to treatment or medication or sex offender treatment. And so, for example, the court might find here that these conditions, these ancillary conditions, would be necessary to protect the public under the Adam Walsh Child Protection and Safety Act. So to say that a person should be able to view pornography or child pornography would be directly contravening to the purpose of the Adam Walsh Child Protection and Safety Act, but might not be something that this court would consider part of the prescribed regimen of medical, psychiatric, or psychological care. And so it seems that it would make little sense for this court to determine that the viewing of pornography would be something that the district court could not enforce in this case, especially because we're talking about someone who is both a hands-on offender and an offender via the use of pornography. I hope that appropriately answered this court's question.
Well, surely part of the psychological care is that you don't look at images of child pornography.
I agree, Your Honor, and I do believe that the prohibition on using or possessing pornography in this case, it does fit squarely within the prescribed regimen of medical, psychiatric, or psychological care.
You were also going to answer Chief Judge Diaz's question.
Yes, Your Honor. So as it relates to Chief Judge Diaz's question, I think something that's worth noting here is not just that Mr. Boyd was kind of coming forward and being what might appear to be honest, but that he actually violated the conditions of his conditional release by not immediately reporting his interactions with the boys at Burger King to his probation officer. So all contact with underage individuals, specifically under the age of 18, under his conditional release order, was required to be provided or notified to United States probation within 24 hours. And the district court did note that in part of its consideration. And as I think we've heard argument on this morning, Mr. Boyd did tell his probation officer, but only when kind of prompted or asked, like, are you having any sexually deviant thoughts? Are you having any, is anything happening that's making you maybe feel a certain type of way? And he immediately reported kind of having concerns about these interactions with children. The fact that he self-identified it early in May of 2022, he should have been able to also self-identify that he should not go back and should not put himself in that situation again. But on May 20th, he reported that he had had another interaction, and on June 4th, he reported another interaction. And so he wasn't really policing his own behavior, and he wasn't doing what was expected of him. And so for all of the reasons that I think the court noted, the court found that there was a pattern of overwhelming evidence that supported that Mr. Boyd was participating in deceptive and escalating risk-relevant behavior. And as Dr. Fox stated during his testimony, he was on the precipice of reoffending. And the district court was not required to wait for him to reoffend before revoking him. And so unless there are any further questions of the court.
I just have one quick clarification. This US v. Roney, you said we're considering it. Do you mean it's being argued this week, or it's just on appeal, or what do you mean by that?
It's already been argued, Your Honor. I believe it was argued back in 2025, and I'm not aware that a decision has been issued yet. I know United States versus Nathaniel Williams has stayed pending the final determination in that case. And so I believe that it's still under review.
Thank you.
Thank you, Your Honor. If there are no further questions, I would ask that this court affirm the findings of the district court and affirm Mr. Boyd's revocation of his conditional release. Thank you, Your Honors.
Thank you very much. Ms. Tarleton? I think you're muted.
I'll get the hang of the Zoom thing one day. First, I just want to start by confirming that on JA 437, the district court expressly said it's not finding that the images are child pornography. This was legal adult pornography that was prohibited for Mr. Boyd, but was not ever found to be child pornography. Second, with regard to the Burger King, pages JA 184 to JA 187, despite repeated attempts by counsel at the revocation hearing, Mr. Boyd was adamant that this happened one time. He said there was only the one time that Mr. Ellis asked a few times. So like he was asking a few times. It was the same individual that I only had the one interaction with. It was never established that this was an underage male. Nothing happened other than the thoughts Mr. Boyd had in his head, which he reported to his probation officer. So the narrative that he kept going back, that he sought out this boy, that he went out of his way to go to this Burger King, none of that is supported by the record. Mr. Boyd was adamant it was one incident with one young man. He had a thought, he reported it to his probation officer, and that was the end of the story. He didn't say he never went back to that Burger King, but he didn't report ever seeing that young man again. So I think that is important on this record. I have a lot of respect for Ms. Petrie, so I just want to say something that she, throughout the course of her argument, she said, we can't be sure. I can't begin to guess. It can't just be a coincidence. And unfortunately, I think this is the same problem that plagued the district court proceedings in this case. In Perkins, this court said, our review of the record leaves much room for speculation where none should exist. And I think there's just too much speculation in this case.
Can I ask you a question about something else Ms. Petrie said regarding the standard of review, which is always good to come back to? You know, you've done a really good job of suggesting that there might be some unease by a particular judge who might have decided this issue differently had he or she been in the district court sitting there for the first time hearing the evidence. But of course, that's not where we are. And so can we really say that the judge was clearly wrong or clearly erroneous given the evidence that is in the record?
Yes, Your Honor, I think we can. Here, you know, the court disbelieved Mr. Boyd and chose to believe the opposite. And on that thin a reed, chose to revoke him and send him back to indefinite federal prison based on speculation and his disbelief of Mr. Boyd's testimony. Where was the forensic exam? Where was the testimony establishing that he viewed these images? Where was the testimony that linked his viewing, which I don't think has been established, of this pornography to a serious difficulty refraining from child molestation? I think, you know, as I started to say in my opening argument.
Weren't there three experts that said that testified that he would have a serious issue?
Eric Fox was the expert who testified that Mr. Boyd would have serious difficulty refraining, but I think his analysis suffers from the same errors the district court engaged in. He assumed that Mr. Boyd viewed the pornography, and I understand why, because he's not a forensic computer analyst. He was assuming that those facts had been established, which is something that experts in these cases commonly do. The problem here is that there was no such forensic analysis to support this revocation. And here we're talking about preventive detention. This is not a traditional criminal case. This is preventive detention based on what a court believes a person might do in the future. Engaging in that kind of analysis is difficult. Judge Richardson has said these types of cases require tough predictive judgments. I would urge this court to really hold the government to its proof in these cases. It's just a preponderance, but they have to do more than they did here. In Perkins and in McNair, this court reversed and remanded for further proceedings. That's because Perkins had not yet been decided and the court did not have the standard in front of it when it issued its decision. That is not the case here. So I would urge this court to follow its tradition of not giving the government a second bite at the apple when it cannot establish by sufficient evidence a revocation in the first instance. That's Pettis in the sentencing context, Nixon in the sentencing context, and both of those are the same district judge. So I would ask this court to please reverse.
All right, thank you very much, Ms. Tarleton. I want to, Judge Bernard, did you have a question or? Okay. I want to say I really, on behalf of my colleagues, I'm sure appreciated the very fine arguments you both presented this morning. Both Mr. Boyd and the United States were very ably represented by you two, so thank you very much. We'll take the matter under advisement and move on to our second case. We would typically come down and greet you personally and shake your hands, but obviously we can't do that today, but thank you nonetheless for being with us.
Thank you.
Okay.
Well, hold on a second.
Sorry.
Delaney, are we okay with the recording?
Yes, we are good to go. Thank you, Chief.
Great, thank you. Our second case is 25-1318, Ruffin versus Davis. Now you may go, Mr. Nichols.
Thank you very much, Mr. Chief Judge. May it please the court. Good morning. My name is John Nichols. I'm here with Mary LaFay. We represent Officer Kevin Davis in this case. I know you're familiar with the records and the briefs. This case requires you to once again tackle the difficult issue of qualified immunity for a police officer in a police-involved shooting. The district court had 3 undisputed facts that she found in her order. Number 1, he possessed a firearm. Number 2, he ignored Officer Davis's repeated commands to stop running, get on the ground, and show his hands. And number 3, JR turned to face Davis in the final moments of the chase, as shown by the impact of Davis's rounds. I would add to that it is not disputed in this case that at the time of this incident, Governor McMaster had issued a curfew order, which Officer Davis was aware of. That's undisputed in this case. It's also undisputed that at the time of the pursuit, between the time he crouched down to retrieve his weapon that we don't know whether he dropped it or he was getting it from his ankle. We don't know why. That is in dispute. But what is not in dispute is that he crouched down at the entryway to the parking lot, retrieved his weapon in his right hand, and he looked at Davis. You can see it on the video, and then took off running again. Now he wasn't running.
Right, and that's when he fired the first, and that's when Davis fired the first shot and missed.
Yes,
and
ma'am.
perhaps then there was a threat, but you were about to say that then he took off running. And it was after he started running away that the officer shot and killed him. What threat was there then?
Judge Thacker, he ran away, but then he's not running away. He's running perpendicular. He's on the
Because there's a fence, because he can't get beyond the fence.
Well, he was
and
at
the
the
building, correct?
Yes, ma'am. He was at the building. He's running perpendicular, and Officer Davis you can see it on the Eau Claire. It's not entirely clear, but you can see it on the Eau Claire video. Officer Davis is standing at the entry to the parking lot, and he's running perpendicular to Officer Davis. And
it's the district court did, as you note, find the 3 points of fact that you outlined, but the district court also found several factual questions that were in dispute, including whether JR actually pointed the gun, whether he was turned toward the appellant to gain a sight, or whether he merely turned his head, as well as the number of shots that were fired, which seemed to be inconsistent. The video is inconsistent with what appellant says. So are we going to believe our own eyes or what appellant says, I guess? But my point is there are factual disputes that the district court found. So how is that, when there are factual disputes that the district court found, how is that appropriate for qualified immunity at this point?
Well, Judge Thacker, I would submit that they must be factual disputes of material facts, and those facts are not material to what
whether he was pointing the gun at the officer would be material to whether the officer would have reasonably felt threatened, would it not?
Well, this court's jurisprudence and jurisprudence from other jurisdictions has held that an officer need not wait until a suspect point a gun or discharge a round.
But the question is whether he was pointing the gun or not. The jurisprudence also says very clearly, including Supreme Court jurisprudence, that you can't exercise deadly force when someone is running away.
Well, and I would submit that he was running away, but he was also running perpendicular and looked at Officer Davis with the handgun in his hand at the time.
All right, so Mr. Nichols, right, let me just...
Yeah, go ahead.
No, go ahead, Judge Thacker.
No,
Mr. Nichols, so right there is sort of, I think that the key issue is you say, I think you're right, that an officer need not wait until a weapon is pointed at him or her before employing deadly force. But what's the case that says that an officer can shoot somebody simply because someone has turned his head without pointing a weapon?
Well, and Judge Diaz, I appreciate the question, but that's not what we have here. It wasn't simply because he turned his head. He is disobeying. He was
No,
given.
that's the question of fact that the district court found. The district court found that there's a question of fact as to what Chief Judge Diaz just laid out, whether he turned his head and whether he was pointing the gun.
Respectfully, Judge Thacker, that was one of the facts that Judge Lyden found was not in dispute, that he did turn to face Officer Davis.
At the time he shot him and missed him. I'm talking about when he shot him 4 times and killed him.
But the round
that's
hit.
the point we need to focus on, isn't it? When he killed him, not when he missed.
Well, the record reveals that the round hit him in the forehead. It is physically impossible.
Right, but Chief Judge, okay.
I'm sorry.
Go ahead.
It's our contention. It's physically impossible for him to be facing the other direction, running away for the round to hit him in the forehead. That was the only round that hit him.
Clearly, that may be the case, but the question is, if he turned his head and was shot then, and there's a dispute as to whether or not the gun was pointed at the officer, so...
Actually, Judge Diaz, we have to accept that the gun was not pointed at the officer.
Not pointed, okay. So tell me, what are the other facts that suggest that use of force in that context was appropriate?
And I have to point out a couple of things. Number one, this entire encounter took 42 seconds, and from the point of the first shot to about the last shot, as by my count, was about 10 seconds. So everything is happening, and what the district court did, what I submit the appellee did, and what this court is on the precipice of doing is to do 20/20 hindsight as to what happened here. It's just natural for human beings to want to fill in the gaps and put an entire picture and look at facts that are really not relevant to what a reasonable officer observed at the time of the shooting. So those facts are, he has been told.
What kind of facts are not relevant? The question, one of the questions of fact that the district court found is whether JR was looking at the officer in order to gain a sight when the officer shot him, or merely turned his head.
Well, Judge Thacker, what she actually...
The officer doesn't get to shoot him, does he?
What she actually said is he turned to face Davis in the final moments of the chase.
Right. And whether he turned toward appellant to gain a sight or merely turned his head, that's what the district court found was one of the things the district court found was a question of fact, I thought.
Well, we don't know why he turned to face Davis.
That's the point. That's the point. That's the point. We don't know. And if he merely turned his head, you're surely not arguing that the officer gets to shoot him for merely turning his head, are you?
Well, at that point in time, he is in the public, he is possessing a handgun.
So you're saying yes, he's possessing a handgun.
I am saying not
you
just
can't possess
because,
a handgun in South Carolina?
I'm sorry, I spoke over you, Judge Thacker. I apologize. What was your question?
I don't know.
You asked if it's legal to possess.
I think you are actually saying that my question was, I said, surely you are not saying that the officer could shoot and kill him for merely turning his head, are you?
No, ma'am.
And then
I am not.
it sounded like you were about to say yes.
Oh, I'm sorry. I misunderstood your
Please
question.
don't say
If the
that.
only fact is that he turned to face the officer, no, ma'am. I am not saying that gave the officer the right to use deadly force. But that's not the facts that we have here. We have Officer Davis attempting to encounter JR, who takes off running. He's told 7 times, stop, get on the ground.
What was his crime? What was his crime that he was being chased for initially?
Well, at that time, Officer Davis was on the scene because they had received information about property crimes.
About what? No, wait, property crimes? I thought it was riding a bike and looking in car windows. Was there something about breaking into the cars? Or was it just riding bikes and looking in car windows?
But that was against the backdrop of Mr. Gunnels telling them that that he was familiar with the fact that there had been prior property crimes involving people
Prior, but
breaking in.
he was not out there for property crimes. He was out there for teenagers riding bikes and looking in car windows.
Correct.
Probably the curfew you were talking about earlier.
And part of the curfew, which, again, they
So
make
he
a,
chased him initially for that. He's pursuing him initially for
well,
riding bikes and looking in car windows.
well, you know, JR did not have a bicycle.
Right,
He-
that was going to
he-
be my next question. He didn't even have a bike, so I'm not sure why he was chasing him in the first place.
But we all know that after the fact, Judge Thacker. We don't know.
No, the officer knew it. That's why he was on the scene. He was on the scene because he was looking for teenagers that were
Right.
riding bikes and looking in car windows. And then he comes on JR, who doesn't even have a bike, and he starts chasing him. And now I'll give you, after the fact, after he's chasing him, JR did have a gun.
JR
I'm
had
just
a-
was curious why he chased him in the first place. And he ended
Well-
up dead.
Well, what he's got is he sees someone walking. He doesn't know if he's ditched a bike or whatever, but he sees someone walking at that time.
That's what.
The curfew is in place. We don't know that whether he's now, we've got a lot of information after the fact that he may have left his job, cashed his check, was carrying $144 and needed the gun for protection, even though he's a minor. We know a lot of facts. after
Apparently
the fact.
did.
We Monday morning, we know a lot of things, but that's not what Officer Davis saw at the time. And what this court has to decide.
And what do you think is the most analogous case to what we're dealing with here?
Well, I think this court's recent cases, I mean, in Benton laid out exactly a pretty good survey of the cases, but there isn't exactly a case on point with these facts. Now,
Yeah, but you think Benton is the best? You think Benton
Well-
is the best, or just that
well-
Benton lays out other cases?
well, I rely on Benton a lot because Benton does a pretty good survey of this court's cases and cases around the country. But certainly.
And you just don't think there are any disputed issues of fact, which is
No.
what the district court found?
Judge Thacker, I can see that there are issues of fact. Well, my argument is that they're not material to the question, that the three facts that the district court found, when you add in the fact of
Well,
government.
I think that goes back to Chief Judge Diaz's question about the disputed facts. You don't think that it's material as to whether or not JR was pointing the gun or merely turning his head?
I think if all you had was JR turning his head, you had no other facts. If all you had was JR turning his head, I agree with you that deadly force is not warranted in that case. And I don't believe any court would find deadly force was warranted there, but that's not what we have. We have he possessed a firearm. He ignored repeated commands to stop, get on the ground and show his hands.
Yeah,
And
did he make the commands right before he shot him 4 times, or were the commands before he shot him and missed him once?
There were several commands before he fired.
So there were commands right before he shot him in the head?
Yes, ma'am. It's on the video. It's on the body cam video.
Right before.
They were before, and then once he saw him crouch down and retrieve the weapon.
Okay, I can watch the video too.
Yes, ma'am. I've watched the video a number of times, quite frankly, and
Yeah.
it's a difficult video to watch, as in all these cases. I mean, this is a tragedy. But this was a tragedy that came on because he didn't obey the police officer when the police officer asked him to stop, get on the ground, and show his hands, and he took off running, and then.
After he chased him for no reason, but okay.
Well, and
Mr. Nichols, I'm sorry to interrupt you. I just
Yes,
want
sir,
to
yeah.
try to focus your attention again on what exactly the officer perceived to be the danger that required the use of his weapon at the point where the young man turned his head, because you've agreed that that by itself would not be enough to warrant the use of deadly force. So and you were getting through the sequence of events that you say painted a fuller picture. But don't our cases then also say, in addition to all the things that appear on the record that would appear to favor the officer's use of force, there has to be some kind of furtive gesture or movement or use of the weapon in a way that suggests that the officer is in danger. So what is the furtive movement or gesture in this case?
We contend that when he stopped, crouched down, grabbed the gun, looked at Officer Davis and took off, and while he's running perpendicular to Officer Davis, looked his way, that was the movement.
So it sounds
Again,
like the turn of the head is the furtive gesture.
While he possesses the handgun in his right hand, Judge Diaz, he.
Okay, I mean, if that's your position, that's
Yes.
fine, but
Well, and if-
I'm not sure that the case, I think there's probably a dispute there as to whether or not a turn of the head is a furtive gesture.
Well, that's going to be a question of law that y'all have to decide. You have to decide
Okay.
that.
right.
I mean, whether there was objective reasonableness in what Officer Davis did is a matter for y'all. It's not for
Okay.
me.
So just to be clear, that's the furtive gesture that you say warrants the use of deadly force in this case.
That and the fact that as he's running perpendicular, he turns and he's got the handgun in his hand. But
Well, that's always going to be the case involving a weapon, right? So it can't be that. It's got to be.
Well,
the
that's
turn of the-
right. I'm sorry, Judge. I'm sorry.
No,
Judge.
is that right?
That's right. The mere possession of a handgun isn't enough. That's
All right.
exactly right. But again, if that's the only fact we've got, then perhaps he didn't. I mean, I think the jurisprudence says if that's the only fact, he possessed a handgun, that's not enough. But that's not what we have here, and that's not what Judge Leiden found.
All right. You're a little bit over, but I'll see if my colleagues have any other questions. Judge Berner, Judge Thacker, you've got some time
No.
left for rebuttal. Mr.
All right,
Nichols.
yeah, thank you, Judge, and we would ask that you reverse, and I'll come back and rebuttal. Thank you very much.
Thank you. All right, Ms. Schnorr.
Thank you, Your Honor. May it please the court, Mary Schnorr on behalf of Plaintiff Appellee Brittany Ruffin. In this interlocutory posture, the court's jurisdiction is limited to a single narrow question, taking the facts as the district court gave them, viewed in the light most favorable to the plaintiff, is Officer Davis still entitled to qualified immunity? Those facts are that at the time Officer Davis shot JR was running away from Davis, at least 90 feet away from him. JR held a gun in his hand, but had not raised it or otherwise made a movement with it. And JR merely turned his head to look behind him while running away. And importantly, this is after Davis started shooting at him. Yet Davis fired at JR 9 times in quick succession without ever giving him any warning. And one of the last bullets that he shot fatally struck JR.
Well, yeah, I mean, to be fair, he did give him warnings earlier on when he shot him and missed him, correct?
He gave him orders to stop running and get on the ground and I believe show his hands, but he never ordered him to drop the gun and he never said, stop running or I'm going to shoot. And that is an important factor in the reasonableness of the use of force.
And right before he shot and killed JR, did he say anything in those seconds prior to shooting him?
Not immediately before, I think, the shot that killed him. This took about 10 seconds that he fired those 9 shots. And so I think quite clearly on the facts that the district court gave, viewed in the light most favorable to the plaintiff, JR did not present an immediate threat warranting the use of deadly force. And I think any reasonable officer would have understood that he could not shoot at JR as he was running away merely because he was holding a gun.
Is it appropriate, Ms. Schnorr, to sort of break this up in the way that you, I think, are trying to do, that is ignoring what happened immediately before JR was shot, with, the sequence of events in the where the young man is crouched and it appears that a gun appears. You say it fell out. The officer says he had it, he brandished it, and that began the fusillade of fire of the officer beginning to fire at the young man So what are we supposed to make of that evidence? That would suggest that the officer appeared or perceived that he might be in danger given the display of a weapon.
So I think the question is whether the use of force was objectively reasonable at the moment the deadly force was used, but that is considered in light of the totality of the circumstances, which of course, as Your Honor pointed out, includes the instance where he slips and the weapon comes out and he picks it up and then keeps running. And I think what's important is that after he gets up, he keeps running and Davis keeps firing at him after it's clear that he is running away. He is not seeking to initiate a gun battle, as Officer Davis put it. And so this court has recognized that even if there might be a threat in one moment, that threat can melt away very quickly as the circumstances evolve. And so I would think that whether Officer Davis had reason to believe that JR posed a threat when he was crouched is, I think, not the question. The question is a few seconds later, when it's clear that he's running away, he's gaining distance with every second. Does Officer Davis have a sound reason to believe that JR poses a threat to him then?
So Mr. Nichols points out that it's not required that an individual point a gun directly at an officer before the threat is sufficient to warrant the use of deadly force. You agree with that, right?
I do agree with that. Yes, Your Honor.
Okay. So, and then he says that this combination of events, even though the young man was running away from the officer, he was perpendicular to him and turned his head, and I think that's exactly what Davis says in his statement to SLED, that he perceived that the young man was turning his head in order to begin, to pose a threat to the officer, and that in turn allowed him to use deadly force in that context. I know you disagree with that, but it's supposed to be the perception of the officer, right? Not reality. And if he perceived that to be the case, why is that unreasonable?
So the question is an objective standard of an officer, a reasonable officer in his position. And so I think there's a question of Officer Davis's credibility. That is what he said, that he was in fear for his life. But a jury could look at all the record evidence here and I think disbelieve that at the moment he shot JR, he was actually in fear for his life and was not just trying to get JR to not be able to get away or just shooting him simply for possessing a gun. And so I think there is as the district court recognized, a factual issue here for the jury about what exactly the turn to face Davis was. Was it him seeming to turn around, trying to get a sight and square up against Davis, or was he simply looking back as he continued running, which is plaintiff's version of events and which the district court acknowledged. And there it's perfectly natural that someone who is being shot at as they're fleeing might look back to see what is happening. It might not necessarily be the prelude to turning around and engaging with him.
So the second part of this analysis in qualified immunity is the question of whether, even if in fact there was a violation of an individual's rights, whether that right was clearly established. And one of the concerns I have is that the district court in this case kind of framed the right quite broadly. She said that it was the right to not use deadly force absent an immediate threat, which seems kind of general, really general and not specific to the facts of this case. Is there a concern about that? I mean, you're supposed to drill down. Obviously, you don't need a case directly on point, but you need something more than a general principle in order to guide an officer and in order to find liability for an officer. So why is that sufficient in this context?
So that's right, Your Honor. I think 2 points in response to that. First, I think if the court agrees with our understanding of what the facts are as the district court found them, which is that JR may have made no movement that could reasonably be perceived as furtive or threatening here, it is Davis who bears the burden of showing that the right here was not clearly established. And I don't think he has met that burden where the only cases he's relying on, Benton and others, involved an undisputed furtive movement or threatening movement by the individual who was shot. But I think also, if reaching the merits, I think the case law here is on point with the requisite amount of specificity. And I think the primary case I would look at is the court's 2017 decision in Hensley, where it also involved an armed individual. And the court said, just because an individual is holding a gun does not mean that deadly force is justified if he hasn't pointed the weapon or otherwise made a threatening movement or a furtive movement. And there, I think if you look at the facts in Hensley, there it's an individual holding a handgun, and there he was on his front porch and the officers witnessed him hit a family member with the gun and then walk down the stairs and walk across his lawn toward the officers. And this court said deadly force was not justified there because he had not made any sort of threatening movement, even though he was walking toward the officers. And so I think even more so here, where JR has the gun but is running away from Officer Davis, it would, as a matter of logic, follow that deadly force could not be used against him. And I think that would be clear to any reasonable officer. And I think that's particularly clear in light of Garner and it being black letter law that you can't shoot someone just for running away unless they pose a threat.
Can I take you back to the sort of the facts, which facts are disputed, which facts are not? Of course, the only other witness to this event is tragically dead, right? It's only the officer who is here available to give his view of the facts. So, and you've got video evidence, but unfortunately it's not as clear as we would want it to be, at least in the key moments that matter. So I wonder how we can say that an officer's rendition or view of the facts is ambiguous in the face of video evidence that doesn't directly refute his view of the facts, or maybe you take issue with that.
So I would say in this posture, in the interlocutory posture, the court takes the facts as the district court gave them and doesn't have jurisdiction to second guess the court's assessment of the record and whether there's a genuine dispute over the evidence here. I think after there is a final judgment, Officer Davis can raise the question of whether there was sufficient evidence here. But in this posture, I think looking at the facts here, it is JR was running away and merely looked back over his shoulder. And on that point, we heard this morning from Davis that he mentioned again that JR was shot in the forehead and that this suggested that he couldn't have been running away at the time he was shot. And he said that also in his reply brief at page 11. And I think on that point, he just doesn't have the evidence necessary to refute and establish conclusively that JR couldn't have been running. So first of all, that's certainly not what the district court said. I think at JA 370, it's true that the district court said turn to face, but on the very next page and repeatedly elsewhere through the opinion, the district court is clear that on plaintiff's view of the evidence, the question is whether he was turning his head while running. And the evidence we have in the record, it is that JR was shot in the forehead, but not straight through the forehead. It was in the left side of the forehead. And then I think additionally, there is the problem that Officer Davis started shooting at JR before it's undisputed that JR turned around at all after he started running. So I think I heard a couple different things from Davis this morning. First, I thought I heard him confirm that he's not arguing that Davis could shoot JR merely for holding a gun and turning his head. But then I think later on, he seemed to suggest that actually that was what he's arguing and that was the furtive movement. I think either way, the argument doesn't work. I think if the head turn is the furtive movement, then he has no cases supporting that view. And I think that's very difficult to square with this court's decisions in Franklin and Aleman, where there also were individuals who were armed and who made some movement, but there were factual questions about what exactly that movement was. And this court said a jury could decide that they were shot just because of their possession of the gun. So in Franklin, there's the individual who is being told to drop the gun. He has the gun in his jacket pocket, and he reaches in to get it in order to drop it and comply with the orders. But the officer said she perceived him to be pulling out the gun and drawing it in a threatening way. And there was just a factual question there. And so I think, and the court said, if he was being compliant and just drawing the gun in a non-threatening way, the jury could conclude he was shot just for possessing the gun. And similarly in Aleman, the court said the jury could conclude that he was shot just for possessing the gun, even though he was raising his arms in the position of surrender. And so I think it's very hard to square the outcomes in those cases with an outcome here where the head turn could somehow be enough to be a furtive movement, and that isn't a question of fact for the jury. And then, of course, to the extent he is arguing that there's something more than the head turn, I think that is adding in facts that the district court found were disputed. And in particular, I think if you look at page 5 of his reply brief, where he recounts what he says are the 3 facts the court found to be undisputed, he's adding in facts to the 3rd fact about turn to face. He adds in this idea of a crouch, which appears to be sort of subsequent to the initial crouch or slip where the gun comes out. But of course, I just don't see that anywhere in the district court's opinion, that it's undisputed that at the moment that Officer Davis actually shot JR, that he was somehow crouched and turning back toward Davis.
If JR had been shot at the moment that he crouched and pulled the gun out, would we have a different result?
I think that's a very different question, and I think there might still be questions for the jury, because on plaintiff's version of the facts, he simply slipped, but I think that is a much closer case. That's very different than the question here.
And you think it's entirely appropriate to sort of separate out these 2 events? I mean, we've done that kind of parsing in some cases, rejected it in others. What is it about this case that warrants that kind of parsing? Because if he's a threat then, why isn't he a threat, 3 seconds later?
I think, well, I guess 9 or 10 seconds later, and I think because he got back up and started running away, and you can see in the video, he is sprinting, he's trying, or a jury could conclude that he's sprinting and he's trying to get away. And again, as this court said, in Aleman, the justification, if there is a threat, it could fall away within a matter of seconds. And so I think this is very similar to that case, where just the circumstances evolved. So we're not saying that the totality of the circumstances has to ignore the incident or what happened 10 seconds earlier, but I don't think it's enough to justify the use of deadly force when it happened here.
You are in agreement that the question of furtiveness is a question of law, so that we have jurisdiction to review that question.
I think that's right, Your Honor, that it would be a question of law, but I think there are questions of fact here. But the question of just simply turning one's head back while running, viewed in the light most favorable to the plaintiff, whether that could be furtive, I think would be a question of law. I just don't think it is furtive. So,
well, if there are no questions of law, then we lack jurisdiction. And so my question is really whether we lack jurisdiction altogether, because really this is a factual dispute, which strikes me, hearing your arguments, that what's really happening is a dispute of fact as to what happened, kind of trying to be packaged in a legal question so that we can have jurisdiction at this very unusual interlocutory posture.
I think that's right, Judge Berner. That's how I understand Davis's argument. It seems to be a question of fact, and whether there could be a question of law, I don't hear him to be articulating that. And so I think, based on following principles of party presentation, I think this court could conclude that it lacks jurisdiction and dismiss the appeal. So to sum up, there are material facts in this case that need to be resolved by a jury. And if the jury credited plaintiff's version of the facts, Officer Davis violated clearly established law by shooting JR as he ran away merely because he had a gun and not because JR had actually threatened Officer Davis or anyone else. So if this court has no further questions, we'd ask that the court dismiss the jurisdictionally barred arguments and otherwise affirm.
All right, thank you very much, Ms. Schnorr. Mr. Nichols? I think you're on mute, sir.
Yeah.
I turned 68 yesterday, please forgive me. Thank you very much, Judge Diaz. I would point you to the City of Tahlequah versus Bond case in which held exactly what you said earlier, that the contours must be so well defined that it be clear to a reasonable officer that his conduct was unlawful in the situation he confronted, and you're not supposed to define it broadly. And I would also point out that in Elliott versus Levitt, the court said the use of it is not unreasonable for a police officer to use deadly force when the officer has sound reason to believe that the suspect poses a threat of serious physical harm to the officer or others. Now, I will concede that if the only fact that is undisputed is that JR turned his head, then we lose. I would concede that if the only fact that we have is that JR possessed a firearm, never pointed it, although that's not required, then we lose. But those aren't the only facts. What we have are he is running. We can't see from the video on Eau Claire High School or the video, the body cam video, what his position is at that time. So that I can't say one way or the other whether, I mean, it would be a dispute whether at the point of impact of the round he had stopped. What we do know is that when the deadly force was employed, he had stopped. I'll just tell you that the Eau Claire High School video doesn't show that he slipped. And again, I'm not saying that that Judge Lyden made a finding on that, whether he slipped or whether he crawled down. I think the speculation is that he had either the gun in his bag or in his waistband, and it must have fallen, and so he stopped to pick it up. But he armed himself during the pursuit. So that's what you have. You have an officer giving him clear instructions to stop, get on the ground, show your hands. You have him arming himself and it's undisputed. You can't look at the video and say, well, Judge Lyden didn't find that. So, I mean, it says what it says, and the video is in the record. I know you've seen it, and you should look at it again. But he arms himself, and then
unless there's a case that presented these exact facts where the court found that there was a reasonable fear, or that a reasonable officer would fear, then everything you're talking about are jury questions, or at a minimum, they're questions of fact, over which we have no jurisdiction at this stage.
Judge Berner, they don't have to be exact facts for the officer to be able to acquire qualified immunity for using deadly force during an encounter like this.
No, but for us to be able to conclude as a matter, we can only review a legal determination. And what you're saying is that under these facts, as a matter of law, we must reverse. And these facts that you're describing, this compilation, it's not really a single fact, it's a compilation of fact, because what you're saying now is you're not simply positing that this turn was a furtive movement, but it's that the turn of the head in combination with the crouch, the pulling out the gun, the run, that it's really a series of facts. And so that strays away from this pure question of law as to whether, if it is even a pure question of law, this turn of the head could constitute a furtive movement. It really seems to me that you're trying to, as I said to your colleague here, that you're trying to repackage a factual dispute as a legal dispute in order to provide us with jurisdiction on appeal.
I understand that was characterized that way in the appellee's brief, and I understand that that's how you have characterized it here. I would submit that I have tried to maintain my argument couched in terms of the facts that Judge Leiden found were not in dispute. And what I see happening and what I saw Judge Leiden do was not, you have to use those three facts. Those three facts are not disputed facts. They're not for the jury to decide. Those facts, well, at this point, you have to accept the district court finding that those were undisputed facts. If that's not enough, I lose. There's no question, Judge Burnett. But we contend reasonableness of what Officer Davis did that day, knowing that he had a gun. He saw him arm himself during the encounter, and that's when the first shot was fired. He has disobeyed repeated commands to stop, get on the ground, show your hand.
We've lost the audio.
Huh.
Yeah, we can't hear you, Mr. Nichols. We may have to just stop right there and see if we can figure out what's going on. You're not on mute. We don't see
No.
that. Oh, there you go. You're back.
Oh, okay. Sorry about that. I'm not sure I remember my train of thought, but
Well, you're over time anyway, so you might just want to wrap up.
all right. Thank you, Judge Diaz. Well, and I want to thank you for today. And I really appreciate the opportunity to come here and represent Kevin Davis before this court. We would ask that you review this record under the undisputed facts and find that he's entitled to qualified immunity as a matter of law and reverse the district court.
Thank you very much.
Thank you.
I want to thank both counsel for their arguments here this morning. Really appreciate your help on this very difficult and tragic case. And Ms. Schnooner in particular, thank you and your law firm for taking this case on pro bono. We are grateful. I know the family of JR is grateful. So thank you both. We'd come down and greet you, but as you heard earlier, we can't, even technology doesn't allow us to do that. So nonetheless, you have our thanks and gratitude for being here today. Take care.
Thank you, Your Honor.
Case is 25-1514, Vickers versus United States. Mr. Wilson, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. My name is Nathan Wilson, and I represent the plaintiff appellant, the estate of Catherine Vickers. May I reserve 4 minutes for rebuttal?
Yes.
Thank you. Ms. Vickers died covered in filth at a subpar nursing facility as a direct result of defendant's failures. The district court erred by rejecting all of her claims, and we asked this court to reverse. While the briefs before this court covered a lot of subjects, in our limited time today, I'd like to focus on the two most critical issues. First, why the district court's resolution of the Federal Tort Claims Act's claims was erroneous, and second, why the district court erred in dismissing the sex discrimination claims. Regarding the Tort Claims Act, the district court found that they were time barred. It found that they accrued in August of 2017. While we dispute that, even if that's true, the district court's application of the continuous treatment doctrine was erroneous and deserves this court's review. Under the continuous treatment doctrine, as this court has recognized in Otto and in Miller, as long as a patient maintains the confidential relationship with their care provider, a medical malpractice claim against that provider is tolled. Now here, the district court found that Ms. Vickers met with her primary care provider, Dr. Hume, in July of 2017, and found that Ms. Vickers met again with Dr. Hume in February of 2018. Yet the district court concluded that the continuous treatment doctrine did not apply because in the interim, Ms. Hume went and saw a specialist. Now, taken to its logical extreme, this is going to create a problematic rule for application of the continuous treatment doctrine. Let's say you see your primary care provider once a year on January 1st, and then you see your eye care provider halfway through the year on July 1st. Under the district court's reasoning, as soon as you see that eye care provider, you have interrupted the care from your primary care provider, and the continuous treatment doctrine would not apply.
Mr. Wilson, can I ask you about that? So I think you actually had a pretty decent argument on that issue, but the district court then went on and decided to claim on the merits, right? So if we agree with that, we don't need to deal with this continuing care doctrine, do we?
Well, we disagree that the district court actually decided these issues for a couple of reasons. First of all, it never says that it's offering these as alternative bases. It says it's only offering them to try and help this court understand the facts. And if the district court says it concluded that these claims were time barred, which means that sovereign immunity would have attached because sovereign immunity attaches to all claims not filed within the FTCA window. But if sovereign immunity attaches, then the district court lacks subject matter jurisdiction. And courts are cautioned all the time. If you lacked subject matter jurisdiction, stop, go no further. You don't have jurisdiction to make findings of fact and conclusions of law on the merits. And that's actually extremely prejudicial to the estate of Ms. Vickers here because she has another federal court case going on in Washington, D.C. right now in the D.C. District Court. And that case is stayed so to see the resolution of this appeal in the Fourth Circuit. And based off the resolution of that issue, the district court is considering applying collateral estoppel to the district court's findings of facts and conclusions of law. But that can't work. And that is a clear error if the district court found it lacked subject matter jurisdiction and then went and entered these findings of fact and conclusions of law that could then be used to collaterally estop a case in a separate district court. So for that reason, we don't read the district court as offering these findings of fact and conclusions of law as binding. And to the extent it did, it would be an error because it found it lacked subject matter jurisdiction.
So what would change though if we were to send a case back, the district court has made its findings, it would simply just re-enter them? Is that, how would that work?
No, Your Honor, the proper remedy would be a remand for a new trial. First of all, because it didn't have, sorry, Judge?
No, go ahead, I'm sorry.
First, because it didn't have subject matter jurisdiction to enter these, or it believed it did not. Second, because in order to reverse its findings on the underlying facts that go to the continuous care doctrine, this court would be striking some of its findings as clearly erroneous, indicating that the district court erred in its analysis of the facts. And then third, we've also pointed out some examples of why the district court's specific findings were clearly erroneous. So for example, the district court found that there was no evidence that the reduction of Ms. Vickers' brain tumor, it improved her incontinence. And yet, as pointed out in our briefs, if you compare her prescriptions before the tumor reduced and afterwards, it goes from being prescribed numerous pads for daily usage to no pads being prescribed. And there's no dispute that all of her other diagnoses remain the same. So the only thing that changed was her tumor got smaller. And yet the district court found it could not credit the expert testimony or itself trace this logical correlation. And there are other errors like that throughout the district court's findings. So for all these reasons, if this court agrees with us on the continuous treatment issue, or if it agrees with us on the equitable tolling issue, the correct remedy is to strike the district court's findings and remand for a new trial.
So when you first opened, you laid out the continuous care doctrine as applicable because of the words you used were maintaining contact, but I don't read that as sufficient to apply the continuous care doctrine. In Otto, what the court says is the patient is excused from challenging quality of care being rendered until the confidential relationship terminates. So is your argument then that there continued to be a confidential relationship during this time period when the daughter was basically calling to report what was going on with her mother?
Yes, Your Honor. So there's several statements in the evidence, whether by the daughter reporting what Ms. Vickers said, that she wanted to maintain Dr. Hume as her primary care provider.
Right, but that doesn't mean that a confidential relationship is maintained simply because the daughter says she wants to maintain, doesn't mean she was. My understanding is what she was doing, in fact, was simply passing along information so that she could call in prescriptions, because under the VA insurance, it was necessary for the VA doctor to call in the prescriptions. But in fact, the care had been transferred to Duke, where there was care for individuals undergoing cancer treatment.
The care for the cancer treatment itself has been moved to Duke, but the types of care is different. Dr. Hume is Ms. Vickers' primary care provider. And so for primary care, and you see that with the coordination of all of Ms. Vickers' other medications with the specific treatment she was receiving at Duke, a primary care provider has to do that. There is no finding that Ms. Vickers saw another primary care provider from July of 2017 to February of 2018. And of course, you don't go in person to see your primary care provider every month. In general, that's only probably a once a year, maybe twice a year meeting. And so the primary care provider relationship remained unchanged, even if Ms. Vickers was receiving specialist treatment for a specific issue. And so that is why the continuous treatment doctrine remains applicable. We would also point out that under the equitable tolling doctrine, to the extent this court were to reach that, it doesn't matter whether it finds North Carolina law or federal law to apply for tolling, because I don't understand the United States disagreeing that whichever one applies. If Ms. Vickers was incompetent, then equitable tolling, whether under North Carolina or federal law, would apply. And this court recently clarified the standards for tolling in Justice v. Clark. Now, while that was a habeas case, this court in doing so spoke generally to the tolling that can apply to any time limitation, and thus analogous to the Federal Tort Claim Act here. And this court specifically held that you don't need an actual adjudication of incompetence. And yet the trial court in its findings rejected the finding that Ms. Vickers was incompetent because there was no adjudication. But this court in Justice says, look to the evidence. So when we look to the evidence, we see Ms. Vickers never lived independently following her hospitalization in July of 2017. On July 3rd, 2017, Hume expressed that there was, quote, serious cognitive decline by Ms. Vickers, and Ms. Vickers was having difficulty comprehending what Dr. Hume was saying. That's on Joint Appendix 1156 to 1157.
These are all factual findings by the district court, for which we provide extremely deferential review. So we would have to find that they were clearly erroneous in order to reverse. What you're suggesting to me is that there's evidence on both sides, and that there's an argument for the other side, not that they're clearly erroneous findings.
The district court's language was no evidence, and I'm providing evidence that the district court somehow missed. That is the definition of a clear error, for it to say there was no evidence and for Ms. Vickers' own primary care provider to be testifying that there was serious cognitive decline. So that's the basis.
Did she testify that she was incompetent as a matter of law?
No, there was not testimony that she was incompetent as a matter of law. But again, Justice says that level of adjudication is not required for equitable tolling to attach. So given that the district court found there was no evidence, and instead the record was replete with evidence of Ms. Vickers' cognitive decline, that was a clear error and further supports equitable tolling.
But didn't her daughter have power of attorney in August of 2017?
Around August of 2017. It might have been a little bit later, Your Honor.
And did her daughter, around August of 2017, become aware of the brain tumor and allege in an email to Dr. Hume that the doctor should have known about it?
That's what the trial court found. I believe this.
Well, that's what the email says, right?
I believe the
I can read
specific
the
language
email.
is disappointment.
Okay. Well, and then the daughter is the one who filed the lawsuit, correct? So a competent person was aware and had power of attorney and filed the lawsuit. That was the daughter. You're not alleging the daughter was incompetent, are you?
No, we're not alleging the daughter was incompetent, but rather that the daughter had to wait until Miss Vickers was deceased in order to have full control over the estate to make that decision. Moving on to the sex discrimination claim, there's sort of two errors here. The first error is the failure of the district court to recognize that this was a civil rights claim as opposed to a Federal Tort Claims Act claim. If you look in the complaint itself, the complaint doesn't mention the Federal Tort Claims Act when discussing the sex discrimination claim, and it doesn't name any specific statute. However, there's no requirement for a complaint to survive a motion to dismiss to actually identify a particular statute. What the complaint...
You're talking about that SF-95 form?
Yes, Your Honor.
Okay, well, it also, you know what else it doesn't mention is gender or discrimination.
So the two...
Isn't that a fatal to your claim?
There's no SF-90 form required to bring a sex discrimination claim in the provision of medical services by the federal government. And even if it was required, the SF-95 says the Asheville VA did not have an appropriate facility for a female veteran of Miss Vickers' age. It reiterates again that the facility wasn't safe for her as a female veteran.
And you're saying that referencing that she was a female is sufficient to allege gender discrimination?
Yes, because it was emphasized that that's why the Asheville VA didn't take her. And the standard for evaluating an SF-95 is only if the government were to investigate this claim, would it understand the basis of liability? And here, if the government were to investigate why Miss Vickers wasn't allowed into the Asheville VA's continuing treatment center, even though it was rated 5 stars, either 1 to 3 best in the nation, and had lots of high-risk older male veterans, it would have found the only reason she was not admitted was because she was female. But those facts...
So can I ask you about that statement in the form? It also alleges, it seems to suggest that there might be an age and physical limitation claim as well. So you've got three separate claims presumably alleged. So how's the district court supposed to discern all of that from that statement?
From the SF-95?
Yes. I mean, it says, the statement, the sentence that you rely on was, where is it? The Asheville VA did not have an appropriate facility for a female veteran of Ms. Vickers' age with the physical limitations she had and emotional vulnerability, et cetera. So those sounds like 3 separate claims.
Well, Your Honor, I think that the most important part is the ending when the SF-95, the end of that sentence, when the SF-95 brings it together to explain why it matters. It's not just the physical limitations. It's not the limited cognition. It's because all those combined, the Asheville VA found it wasn't safe for her as a female veteran. Because a continuing care facility applies, it takes care of people with physical limitations, with cognition difficulties. The only reason it didn't work here was because she was a female veteran. So looking to the extent the SF-95 is required, the text of it satisfied the standard of presentment. But again, for a civil rights claim of sex discrimination against the federal government in the provision of medical services, SF-95 and presentment is not required.
Then you have the other problem, though, that you then expand the basis, the legal basis for the claim as being related to the Affordable Care Act, which is the first time that statute makes an appearance in this case on appeal. So the district court never had an opportunity to engage with that specific theory. So why isn't that claim forfeited?
The claim is not forfeited because in her submissions to the magistrate judge of evidence to support her discrimination claim, she noted that she added a VA form 10-0381, that's on Joint Appendix 178, which is a civil rights claim against the VA. So it was against the district court, and correct, the specific statutory citation was not cited before the district court that I can find, although it was in our interlocutory appeal and it is now here. That being said, that is just an enforcement statute for the type of claim, which is a sex discrimination claim for deprivation of medical services, which is clear from the face of the complaint. And if your honors have no further questions, I'll save the balance of my time for rebuttal.
All right, thank you, Mr. Wilson.
Thank you, your honors.
Mr. Letzring?
Good morning, your honors. May it please the court. My name is Jonathan Letzring, and I'm here on behalf of the United States. After several years of litigation that culminated in a 4-day bench trial, the district court correctly ruled in favor of the United States in this FTCA medical malpractice case. The district court got it right, and its judgment should be affirmed. Judge Reidinger made extensive factual findings and credibility determinations in his 69-page order following this bench trial, and ultimately correctly concluded that the estate failed to prove its claims. As the court is aware, there were multiple grounds supporting the district court's decision. I'd like to first talk about something that was brought up by Mr. Wilson, and that is the notion that the district court did not reach the merits of the claims. That is incorrect, as I see the district court's order. The district court never concluded that it did not have subject matter jurisdiction. And in fact, under United States v. Wong, which is a case, ironically, that the appellant cites in their brief, United States Wong is an FTCA statute of limitations case. And in that case, the Supreme Court found that for statute of limitations purposes, that issue is not jurisdictional. So ironically, it may have been an error for the district court if it had said that there was no subject matter jurisdiction. But in any event, the district court addressed the issue of timeliness because that was an issue that the government had raised throughout the case, and correctly concluded that the claims were not timely. And that was based upon extensive factual findings and a full record at trial. Unlike most of the statute of limitations cases and most of the continuous treatment doctrine cases that are reported, this one is very different because it was handled at a bench trial. So we had not only, I'm sorry, did I echo?
You did, but I think you're fine now.
Okay, my apologies. So not only did we have the medical records themselves, but we also had Ms. Roos's testimony as well as Dr. Hume's testimony. And there was nothing that was clearly erroneous about the district court's findings in that regard. Judge Berner is correct. The finding was that there was no confidential relationship as of August 30th, 2017, as between Dr. Hume and Ms. Vickers. At that point, the district court found that the relationship had changed to a point where Dr. Hume, while still involved in the loop, her role was administrative in nature. It was not to treat the underlying condition for which we are now here, and there's a claim that somehow there was negligence.
Can I ask you about that? Is that
Yes.
what's required? I mean, if she had remained as Ms. Vickers' primary care physician, treating other issues beyond the issue that forms the basis of this case, you wouldn't say that she wouldn't. I mean, that she wouldn't have continue to have a doctor-patient relationship, would you?
Your Honor, the question you asked is a good one because the continuous treatment doctrine cases, as I read them, are a bit murky as to the outer limits of what that doctrine is. I think the difference here is, Ms. Vickers had been not only physically transported to Duke, but Duke had taken over her care for her brain tumor. So this is not a case where, Ms. Vickers was going back time and again for other medical issues with Dr. Hume. If that were the case, I could see it could be viewed differently. In fact, one of the plaintiff's experts in the case, Dr. Friedman, he actually admitted and acknowledged that the quarterback for the care for Miss Vickers' brain tumor was the Duke facility, not the VA. So I would also add that this case doesn't fit within the rationale of the continuous treatment doctrine. The idea of this doctrine is we don't want to put a patient in a difficult situation where they're required to contest or to challenge the care that they're receiving while they're still receiving it from that particular provider. But here, as we know, by August 28, 2017, Ms. Roos had already complained about Dr. Hume and a message from Ms. Vickers' VA online portal. So I would also submit that this case doesn't fit within the rationale of that doctrine. And finally,
how are we reviewing that determination on the part of the district court? Is that a legal determination, or is that a fact determination, or a mixed question?
Judge Berger, I want to make sure I understand your question. Are you asking about specifically the rationale piece that I just asked about, or that I just mentioned?
I'm asking about the application of the continuous care doctrine.
Right. So I think it's probably a mixed question to some extent. I think when it comes to the application of the doctrine, it necessarily requires the district court to engage in factual findings. The district court has to look at the nature of the relationship. It had to review the medical records. It had to hear Ms. Roos's testimony, where, of course, she was at some of these appointments. What were the purpose of these appointments, as well as the testimony of Dr. Hume. So there are certainly factual findings that underpinned the district court's determination on this issue. I would finally mention that this is an issue that the estate carried the burden on, not the United States. The estate carried the burden of showing that the continuous treatment doctrine applied, and they failed to show that it did. Now, putting that aside, there were multiple other bases upon which the district court's decision is supported and upon which it was grounded. One of the primary findings is there was no breach of the standard of care. This came down to a classic battle of the experts, and the estate's claims hinged on the theory that 2 and only 2 of Ms. Vickers' primary care physicians at the VA in Asheville somehow breached the standard of care by failing to diagnose this tumor sooner. And Chief Judge Ridinger conducted a thorough and careful review of all the evidence that was introduced at trial, and ultimately found that our experts, the United States experts, were more credible than plaintiffs. For instance, the testimony of the estate's primary care expert, Dr. Bondar. The district court found her testimony to be entirely unpersuasive. Now, the court may be aware there was some testimony in this case that was submitted by deposition, but this was not a case even where the depositions were submitted in paper only. This was a case where there were video depositions of these physicians. So the district court also had an opportunity to review the demeanor of Dr. Bondar and see her credibility while these questions were being asked of her. And she admitted she had not served as a primary care physician since 2011. She couldn't articulate when the VA primary care provider should have provided Ms. Vickers a neurological consultation. And of course, Ms. Vickers' symptoms were nonspecific. Meanwhile, on the other hand, the district court found the testimony of the United States primary care expert, Dr. Spangler, to be much more credible and useful. He was a professor of medicine at Wake Forest University and is a primary care physician. And he explained, importantly, that when Ms. Vickers came to see Dr. Hume in 2012, she was medically encumbered at that point. She had numerous long-standing medical problems. That included PTSD, insomnia, morbid obesity, osteoarthritis, fibromyalgia, diabetes, and urinary incontinence, which she had suffered from for years. And Dr. Spangler, looking at this constellation of symptoms, opined that the issues that Ms. Vickers experienced while she was under the care of both Dr. Hume and Dr. Raj Kumar were nonspecific and much more reasonably attributable to these many comorbidities than ever to a brain tumor. And she also had an unfortunate history of noncompliance and mental health issues, which further complicated her care. So for all of those reasons, after reviewing the totality of the evidence, the district court correctly determined that the estate failed to prove that there was a breach of the standard of care. The district court's order didn't stop there. It also looked at the question of causation, and it examined that issue to see if the estate, even if there had been some sort of alleged negligence, which wasn't proven, was there any causation with any alleged injuries? And again, this issue boiled down to a battle of the experts, with the United States as experts found to be more credible by the court. Ms. Vickers passed away at the age of 83 on October 16, 2018, from cardiac arrest secondary to septic shock and likely urinary tract infection. Dr. Bales, he was the United States expert, the only neurosurgeon who testified in the case. He explained that the brain tumor, an alleged delayed brain tumor diagnosis, did not contribute to her death. The tumor wasn't operable in 2017, nor was it operable in 2003 due to its location and characteristics. He also opined that the timing of the diagnosis did not cause any diminution in the quality of her life. Because of all of these comorbidities that I mentioned, according to Dr. Bales, it would not have made a meaningful difference if she had received chemotherapy for her brain tumor sooner. So we have multiple bases supporting the district court's decision, and all of those findings underpinning that are factual findings, which this court should give deference to.
Wasn't there also evidence that the brain tumor had been successfully treated, even if delayed?
Correct, Your Honor. There was. The chemotherapy treatment that Ms. Vickers received did successfully treat her brain tumor. I note that Mr. Wilson mentioned, I believe, when he was arguing that there was somehow also evidence that her urinary incontinence improved. I don't see the evidence that way, and I don't think the district court did. There are some loose references in a medical record, perhaps, to certain needing fewer supplies at some point in time. But there was the experts were actually asked this specific question. Dr. Hatcher, the United States urology expert, was asked this question: was there any evidence that Ms. Vickers' urology issues, specifically her urinary incontinence, did that improve after she received chemotherapy? And the answer was no. There was no indication in the medical records of that occurring. Same with Dr. Bales, the neurosurgeon. He also examined that issue and too found that. But that was sort of that the urinary incontinence issue is a bit of a sideshow, because ultimately the urology expert for the plaintiff admitted there was no breach of the standard of care in any of the urology care that was provided to Ms. Vickers. So having talked about the merits as well as the statute of limitations issue, I'd like to now turn to the gender discrimination claim, which was mentioned earlier. So the district court dismissed this claim correctly for a failure to exhaust. We have two documents we have to look at when we're analyzing this claim. We've got the SF-95, the administrative tort claim that was brought, but we also have the federal court complaint that the district court was also looking at. As I believe it was Judge Thacker noted, the administrative claim, although it mentions gender, it does not articulate any sort of gender discrimination claim or any desire to bring a gender discrimination.
It doesn't really even say gender. It just says female veteran. It
That's
identifies
right.
her gender, but it doesn't say gender.
That's right. There's nothing that would have given the VA cause to have believed that she was attempting to bring some sort of gender discrimination claim in this case at the administrative level. Now, the argument on appeal is, well, the district court should have analyzed this claim differently. A gender discrimination claim isn't typically a tort, and so it should have looked at it under the Affordable Care Act. I think, as Judge Diaz mentioned, that was not argued below. That this Affordable Care Act theory was not argued below. I think Mr. Wilson mentioned something about a civil rights complaint. As I recall the district court's handling of that, there was no evidence the VA actually received that civil rights complaint. So that was that didn't advance the ball at all for the plaintiff. I would also point out something that I think is very important with regard to this claim, and that is if the court looks at the federal court complaint that was filed by the estate, paragraph 10, JA 19, quote, this case, and maybe I'm paraphrasing a bit because it's a portion of a quote, but this case is commenced and prosecuted against the United States pursuant to the Federal Tort Claims Act. The district court reasonably construed the complaint as being filed under the Federal Tort Claims Act because that's how it was pled. And therefore, of course, they're going to look at, the district court is reasonably going to look to see if the claims have been exhausted in accordance with the FTCA. And I would also add, the estate never objected to the dismissal of this claim at the district court level, saying it should have been analyzed under a different statute. In fact, it actually doubled down. The estate argued that it did present the claim properly in its SF-95. So giving the district court even more reason to have analyzed it under the FTCA. Now, as a practical matter, I'll just add this claim, even though the district court didn't reach this issue, is entirely meritless on the face of the complaint. The theory that the VA should have placed Ms. Vickers in a facility for high-risk males, the complaint itself that Ms. Vickers, that the estate filed, acknowledges that they didn't do that for safety reasons because she had been rejected from multiple facilities and removed from one facility due to inappropriate sexual behavior that had occurred at that facility. So for good reason, she wasn't put into the facility for high-risk males. There were other issues, obviously, that were raised in the briefs, but I'm happy to, but I'm content to rest on my briefs as to those issues. And I will conclude by again reiterating that the district court's order reflects a diligent, thorough, and careful examination of the facts and law upon a full record at trial. The conclusions were well reasoned and fully supported by the record and the applicable law. The estate has not come close to carrying the heavy burden that would be necessary to overcome the many factual findings and credibility determinations that underpin the district court's judgment, nor has the estate demonstrated that the district court misapplied the law in any way. If there are no more questions from the panel, I will conclude by respectfully requesting that this court affirm the district court's decision in favor of the United States. And I will yield the remainder of my time.
Thank you very much, Mr. Lettering.
Thank you.
Mr. Wilson, you've got some time for rebuttal.
Thank you, Your Honors. So I'll go in order of the arguments I heard to the most important ones I addressed. A quick clarification on Wong. Yes, Wong said that the 2-year FTCA isn't a hard jurisdictional limit such that it can't be told, but it never changed the effect of when that statute of limitations applies, what happens then. The government tells you on pages 60 to 61 of its brief. Once the statute of limitations attaches, sovereign immunity kicks in. And if sovereign immunity is kicked in, then the district court lacks subject matter jurisdiction. Going to the continuous treatment
You
argument.
raise these subject matter jurisdictions in your brief, these subject matter jurisdiction arguments?
We mentioned jurisdiction specifically in the reply, and then in our opening brief, we argued that it was error for the district court to go further beyond resolving the statute of limitations claim or the statute of limitations issue.
And doesn't Wong specifically say that the questions of the time limits are nothing more than time limits and that they're in fact not jurisdictional?
Yes, as far as tolling. But Wong doesn't change that whenever that line gets drawn, then sovereign immunity does attach. And I don't think Wong changes that once sovereign immunity attaches, then it's a subject matter jurisdiction issue. Moving on to the continuous treatment issue, I know there's been some discussion about what treatment Ms. Vickers was receiving from Dr. Hume in the interim. First, if one is only seeing their primary care provider once or twice a year, the fact that one sees a specialist is not an interruption of the primary care provision. But even so, looking to the joint appendix, you see on September 4th, 2017, Dr. Hume sent an information packet to Ms. Vickers discussing how to handle medication. That's on JA 2876. On September 20th, 2017, JA 2853, she discussed the benefits of condensing lab draws. Dr. Hume discussed that for Ms. Vickers. Then on November of 2017, JA 2890, she provided a recommendation on diabetes management. What this shows is that throughout her specialist treatment, Ms. Vickers was continuing to rely on Dr. Hume for primary care provision. There was not an interruption, nor was there a finding that there was an interruption in primary care provision from July of 2017 through February of 2018. And while the outer limits of the continuing treatment doctrine might be murky, they are not murky here under these facts, and the trial court erred in finding they did not apply. If I can provide some quick clarifications on the factual disputes regarding the standards of care and breach of causation and why there were clear errors. The district court said it found Dr. Bonder unpersuasive because she said she wasn't a primary care physician. Her actual testimony is that she wasn't labeled a primary care physician because she is a hospitalist, but they essentially provide the same services. They were both certified in both Dr. Bonder and Dr. Hume were certified in internal medicine, and that was the medicine they both practiced. And then as far as causation, the argument is not that the brain tumor caused the death itself. The argument is the brain tumor caused increased urine leaks, which led to unnecessary treatments that then led to an antibody resistance that killed Ms. Vickers. And Dr. Hatchard limited his testimony to express no opinion on the impact of the tumor after 2014 when it could have been treated. For these reasons, Your Honor, we ask this court reverse the district court. Thank you.
All right, thank you both for your fine arguments this morning, I guess still morning. I'm sure the panel is grateful for your presentations. And Mr. Wilson, I want to thank you in particular, since you jumped in here at the last minute and agreed to take this case on pro bono. Thank you for doing that. And again, thank you both for your arguments. We would come down and greet you, but obviously cannot do that, but we're grateful that you're here with us today.
Thank you, Your Honors.
Thank you, Your Honor.
With that, the court will stand adjourned until tomorrow morning at 9:30.